Hello and welcome to Off the Fence, a podcast where we deconstruct difficult decision making to try to figure out what keeps us stuck and, more importantly, how do we get unstuck. I'm your host, Karen Covey, a former divorce lawyer, mediator, and arbitrator turned coach, author, and entrepreneur. My guest today is Raiford Palmer. Raif is an experienced Illinois divorce attorney and the best-selling author of I Just Want This Done: How Smart, Successful People Get Divorced Without Losing Their Kids, Money, and Minds. And it was named the best family law book of all time by Book Authority. Raiford has been featured in prominent media outlets, including the Associated Press, the Los Angeles Times, Forbes, Newsweek, U.S. News, the New York Post, SiriusXM Radio, and WGN Radio AM 720. With nearly 30 years of experience as a lawyer and mediator, Raiford is the CEO of STG Divorce Law PC, a law firm focusing solely on matrimonial law in the Chicago area. He's a fellow in the Illinois chapter of the American Academy of Matrimonial Lawyers, the AAML, and Raif is married to his law partner and fellow AAML fellow, Julie Gumina, and they have a blended family of 2 sons and 2 daughters. Raif, welcome to the show.
Thanks, Karen. Great to be here. I appreciate it.
Oh, it is wonderful to have you here. And I can't get past the first question. I'm so curious. What's it like being married to your law partner in a family law firm, and how did that happen?
It's great. It's a family business. That was not something I expected initially. We have been married since 2018. We met each other in the law firm, and we were both owners of the firm at that time with another person. So Julie, my wife, got divorced. I got divorced a year or so after that, and we got together after that. And it worked out very well, actually. That was not something I don't think either of us would have ever expected. Just the nature of who we are as people and everything, we didn't really know. I had no idea for sure, but it's worked out very well. We get along real well in the business. And personally, our values are aligned, which is very helpful, obviously. And we both need the law firm, want the law firm to be successful. It's how we feed our children, it's how we pay for college and all those things. And we love our team, the people that work with us in our firm. And we're both the same age. It's been a career for both of us for decades. So the main thing is she does very different work than I do in the business. I manage the law firm and she still handles, active clients. I have a few clients. She has a full caseload.
Okay, that makes a lot of sense. So you kind of go on different tracks. But how does or does your relationship and the fact that you are both divorced, you are remarried, working together, all the things, how does that inform the work that you do with clients?
It certainly I'll speak for myself, it makes me much more compassionate, I guess, or understanding, because it's very different when it's your own divorce and it's not clinical, when it's a legal problem to solve. Of course, you care about your clients, and I've done personal injury and I've done business litigation and transactional work before I did divorce. And if you don't care about your clients, you won't be a very good lawyer. But it becomes very different after you've gone through the process yourself, and you do gain a certain additional empathy and very valuable perspective for what your clients go through in the process. And it's no longer an academic problem. It's very real. And you understand the emotional side of it much more, and the way that you feel going through it. Even if you have a quote unquote good divorce, that's still traumatic. So I would say that's informed us and made us better lawyers, because we both have I think, a higher degree of empathy for our clients from going through those experiences.
That makes a lot of sense. But something you mentioned, I want to follow up on something
Sure.
about, that when it's your own divorce, you don't have the same perspective, which is good and bad. And I wanted to use that as a springboard to talk about something that so many people think they can do now, which is to do their own divorce, that go the DIY route. And I don't know about you, but I've had clients who wanted to do that and seen people who want to do that who have a lot to lose. Like they have
Right.
money, they have kids, they have property, they have all the things. What's your feeling about DIY divorce, and like should people do it? Should people not do it? What are the considerations?
So I'm in general, I'm not a fan, but certainly it depends. If you have a simple divorce, very straightforward situation, it can be done. It can be done uh, relatively well. There's so much fear, understandably so, by people in the general public about the fees and the trouble they'll get into in a divorce court, that I think the reaction and the fear, the reaction to that fear has been so severe. People are now really struggling with pro se or self-represented cases. And in our family, we have a support group on Facebook, the Illinois Divorce Support Network, and it's free to join. And people are in there all the time navigating do-it-yourself divorces and asking a million questions that a lawyer would easily know, and the lawyer's staff would know. Routine things like, how do you file this, or what documents do I need? Very basic things. But the court system is, as you know, very complex, and the system has not simplified itself to the point where there's some easy do-it-yourself divorce. And every county is different. Even each individual judge is different in the state of Illinois, and this is true across the country. And the world's really not built very well for people to be self-represented in divorce without some assistance from a lawyer. It doesn't necessarily mean the lawyer has to be there standing there in court for them all the way through, but to be coached by an attorney or have the attorney help with doc prep and making sure all the paperwork is in order and filed correctly. We provide sort of coaching services and varying levels of support to clients who don't necessarily need a full attorney representation, but need guidance. And there are a lot of lawyers that are willing to do that. And I think folks are so scared of hiring a lawyer, they miss that opportunity, and they end up doing the equivalent of do-it-yourself dentistry, which is like, it's as bad as it sounds. It's like, I'm so afraid of spending some money on it that I'm going to go try it myself and run into all the related problems and end up costing yourself a lot more money in the end, end up getting a lawyer anyway, backtracking, reworking things, wasting a lot of time in court. So I tell people it's like akin to doing your own bathroom. You could do your own bathroom. You could remodel it. You could learn how to do plumbing, electrical, install the fixtures and tile and all that stuff. But it'll take you umpteen hours and tremendous amounts of trying and redo efforts. Or you can hire somebody to do it for an amount of money and get it done right the first time. So it's, as you said, there's a surprising number of people with pretty complex cases with a lot to lose who are so in fear of spending money on lawyers, they avoid it altogether and end up in a lot of trouble. That's not to say people don't get it done, can't get it done on their own. They do. But you're right. I think a large group of folks who they have a misapprehension that lawyers will only demand that they will do full-on representation, that it will cost a fortune. And when they have an uncontested case, it's not expensive as
Right.
divorces go. It's just not. And you can get, some lawyers will do fixed fees, so a flat amount of money, or a modest hourly, an hourly rate, but the sum is not very high. So you're talking about in a lot of cases, several $1,000s, not tens of thousands of dollars. So and it's a bargain relative to the peace of mind and the financial security you're buying. We're dealing with assets worth multiple hundreds of thousands of dollars, 401k, pensions, people's real estate. And you're absolutely right. So and these issues aren't all that simple. The law is complex, constantly changing. And yeah, so you make a good point. So I'm concerned that there are a lot of people out there missing out on good representation and the advice that would come with that and the protections that come with that in their fear of spending some money when it's probably a lot less expensive than they think.
Yeah. And I think that it's not just the fear of spending the money, but the fear that the lawyer is going to stir the pot,
Yes.
because I don't think they understand that you can hire a lawyer these days for discrete services. Like you can hire someone just to do the documents. You can hire someone just to talk you through, what should you be thinking about and what are your rights and responsibilities and all those things, right?
Yes, exactly right. And you're right. People aren't aware of what we call limited scope representation, where you can define narrowly the role that you want the lawyer to follow. Now, there are some law firms and lawyers that won't do this work, but many will. And all you have to do is ask. And those those unbundled services are available out there for people who want to pick a la carte off a menu. There are firms that will be happy to do that. And we'd rather have people represented and get it done properly. We'll represent people in any capacity, whether it's full-on representation in litigation or mediation or collaborative, or if they just need us for a little bit of advice. Can you look over these documents for me and tell me if this is what I believe it to be? Sure, we can do that. So you're right. It's a missed opportunity. I think probably a marketing effort or a failure on the part of lawyers to make it pretty well known that those services are available also. Um, but yeah, a lot of people could be well served by telling lawyers what they need and asking for specifically what they need. And that leads me to one other issue that ties into this, and that is that clients need to know they're always in charge. And when you talk about the runaway train issue, and I talk about that in the book, like the bulldog lawyer, the fear is this case is going to get out of control. I'm not going to be in charge anymore. And ethically, the client's always in charge, as you know. And so the client is always able to tell the lawyer, I don't want to do something. And they are always the boss. So it's important that people understand their role. The lawyer is always required to follow the client's instructions.
Yeah, 100%. And you're right. I think that people don't know that, and lawyers, let's just say they're not always the best at marketing.
Well, true.
So I'm
Right.
not even going down that rabbit hole.
Right.
But yeah, I think that the clients need to know that they're in charge and feel that they're in charge. And a lot of times I think that once they turn over the case to the lawyer, they lose control and it just goes however it goes. And that doesn't need to be true at all. But I'm
Yeah.
glad you mentioned your book because I really want it. First of all, the title is amazing. I love the title.
Thank you.
That's really
Yeah.
good.
Got a copy right here. Thank you very
It
much.
just happened to have it right there. That's perfect.
Thank you.
So tell me about the book. How did it come about? Why write it? What do you want people to know?
So I wrote the book out of frustration in 2020 that there was nothing else like it. I wanted a book for our clients of our firm to give them kind of the what for and why is about divorce. There are books that tell you to go to war. So there are books that tell you, you need to fight, and they tell you how to, go to war and fight and win. There are books that tell you to not get divorced. There are books that tell you it's okay to get divorced. There are books that tell you how to stay married. But there was no book that was sort of a tell-all or almost like a confessional about what divorce lawyers know, those of us who've been in the trenches, what we know, what the reality is, and what I wanted people to see and understand, and the things that I told clients again and again over the years about the reality of how these cases work and why things are the way they are. And I would have these conversations with clients and say, for example, I would explain why the lawyer on the other side seems like a runaway train, or why the case is devolving and it seems like the litigation is endless. And I would say, I wish I just had a book I could point you to to read the chapter, whatever, and you would at least understand all this stuff that I just know from doing this. And then we could have the conversation about what to do and
Yep.
save an hour long conversation. You could look at the book. And that's really where it came from, was to talk about that. And also, to some extent, it was a manifesto about how I wished divorce law was practiced, because I do see it done improperly. And I do see lawyers not doing things the best way. And I wanted to emphasize alternative dispute resolution and so mediation, collaborative. I wanted people to know those options existed, what the pros and cons were. I wanted people to understand cost benefit analysis and how divorce lawyers look at their cases, and just understand the reality of the situation rather than going into it blindly. So it's really meant to be a primer on the process. It's not tied to any specific state. I don't go into detail on how child support works or alimony or custody and visitation. That's not what it was meant to be. There are plenty of websites that explain that. It's meant to be a guidebook overall for the whole process and the way to think about it, and the do's and don'ts.
That sounds that sounds really good for clients. I wish that it had been out years before it came out. Um, but I'm fascinated by the concept you mentioned, cost benefit analysis and how lawyers think. Now, as a lawyer myself who's been in the trenches for more decades than I care to admit, I get it. But for the benefit of our audience, can you explain, like, what are you talking about when you say the cost benefit analysis and how a lawyer is going to analyze a divorce case?
So Karen, yeah, first it starts out with understanding that an awful lot of people spend a lot of money and time, and this goes to people's fears. So some of it is stereotypes are based in fact, like fears are based in some reality. So it is true that some cases are runaway trains and some cases do devolve into chaos. And some the thing I want people to know is that there was a lot of money and time spent trying to push the needle in the case a few degrees off of center. So if you imagine equal being down the middle, and I
Hmm.
imagine this needle on a gauge moving a few ticks left or a few ticks right towards one person or the other, whether it's visitation or whether it's division of assets, a lot of people spend a whole lot of money and grief trying to push that needle in one direction or the other, and they're just not typically not going to be successful. It won't move as much as the money they've spent or the energy and the grief. And there are people that are either misinformed or they just don't understand that all that effort is not going to necessarily result in the gains they expect. And the problem is they never compare the cost in money, time. They don't understand that the costs are beyond just attorney's fees. So it's emotional cost, it's the drag on your career, the
Yep.
effect on your children, your family writ large. Um, the additional financial costs, not just for attorneys, but people spend more money while they're getting divorced. They're buying clothes, they move out to an apartment, there's just additional cash being burned. And that they find at the end, when the dust settles, that the money and the time all spent on that weren't worth whatever difference they might have gained. And many times there is no difference. And that's the thing that, once you submit that to a judge, the matter is out of your hands and a court's going to decide your case. And they are I tell people it's not a scalpel, it's not laser specific surgery. It's kind of like a hatchet, and it's not perfect. The judge can't know all your specific details. They don't know your whole life. They don't know your spouse's life story. And even though you have a trial, the court only will see a subset of the facts that make up your entire existence. And so at best, you get a result that it's an attempt to get an equitable result, but it may not be, it's not going to be anywhere near as good as something that's reached by settlement, by a negotiated agreement.
Right. And I think what people need to hear, and I think you're trying to impart to them, is that nothing is perfect, but at least with a settlement, even if you don't like everything about it, and you and I both know, we always joke that the best settlement is one where no one's happy, right?
Right.
Everybody gave a little more than they thought they should, everyone got a little less than they thought they should. That's a good settlement, right?
That's
And
right.
that, but even that, imperfect as it may be, is probably going to put you in a better place than letting a judge who doesn't know you and has never met you until the day you walk in the courtroom decide, your fate and the fate of your children.
Exactly. And it's, you know, the thing with cost benefit is to get into how we look at it, it's first establishing what do you think is a realistic outcome at trial. So if we had a trial, first of all, what do we think is a realistic outcome? What are the chances at the parenting time you want? Or, it's one thing when it's black and white. It's easy when it's a binary yes, no situation. So when it's my soon to be ex wants sole custody and now I want sole custody. Well, we're going to have a trial. There's no middle. So those are the easy ones. And not easy to do, but they're easy decisions because there's no settlement to be had. The question is, if we're debating like, well, I want a little more visitation time and my soon to be ex is not agreeing with that. And so we're debating over that. And maybe on the money, we we think the asset division should be 55% to one party and 45, 55-45, or some person says, well, I think it should be 50-50. Well, first of all, what are the chances you're going to get that 55% from the court realistically? Assessing, and then what is that difference worth, or what we call the delta. So what is that 5% worth off of center? Is it $100,000? Is it $50,000? So what is my chance of getting 55? How much is that worth? And then what is it going to cost to get there? And when you weigh that, when you look at all those numbers, it's not that complicated, really. You can then see, oh, I stand to gain 50,000 bucks, but it's like a 50-50 chance, my lawyer's telling me. So that's really sort of like cut that in half. That's like $25,000. And my lawyer's telling me it'll cost $50,000 to get there. Well, you're going to gobble up any gain in attorney's fees, not to mention your emotional energy and time. And it's going to take another year or whatever, several months. So to boil it down to the essence, it's you don't want to chase $5,000 by spending $10,000. That's how I explain it to clients. And then everybody understands that. And
Right.
so we have to go through a little bit more complicated analysis, but it's not that hard to understand. If the time and money and grief gobbles up the potential gain, then you need to settle now with the deal that's on the table. So,
Yeah. That makes so much sense. And you and I both have seen over the course of our career clients who didn't make that decision and
right,
they spent, double, triple, quadruple in fees, and not to mention the time and grief and all the other stuff.
right,
The extra that they ended up getting, it didn't make sense.
right. And unfortunately, what happens, look, there are some attorneys out there that don't educate their clients well about these situations, and the clients potentially says, I want X, and the lawyer says something vague like, okay, well, I can't guarantee it, but we'll do our best. And that's not really informing the client of their real chances of success.
Yeah.
And some attorneys sort of hide behind zealous representation, which is under our ethics code. I'm not preaching to the choir, but under our ethics code, we're supposed to zealously represent our clients, which some lawyers, I think, take as sort of like, well, I'll do what my client says. Well, yeah, but I believe in informed consent, like a doctor. I think the client deserves to know what they're getting themselves into and what their realistic chance of success is, not, well, it's a decent chance, or, well, maybe, I think lawyers owe it to their clients to try to give them a better concrete answer. Now, I know that nothing's guaranteed, but lawyers with experience generally have a very good idea how judges rule on given topics under certain fact situations. And most of these cases fall within very familiar patterns. And courts think about these things sort of in boxes. They kind of, like we all do, we categorize things, and we know a typical marriage, let's say let's talk about Chicago area, a 20-year marriage, let's say 1 million in assets and both people make a decent income. They're going to divide the assets 50-50, all things being equal. And that's very common. It's an
Hmm.
unusual outlier when the assets are not divided equally. That's much less common. And
Yeah.
so, as an example, and so are, unusual maintenance awards. So we talk about alimony. We have a formula. Getting anything more than the formula is hard. You know, Getting less than the formula is difficult. And telling the client, well, maybe, doesn't fully tell the client, really, it's a no, but we can throw the spaghetti against the wall and see what sticks. And that's where lawyers need to do a good job educating clients about reality of the situation, I think. And not just at the end of the day when the trial result comes and the judge says no, the client says, what happened? And the lawyer says, gee, well, the judge just decided against you. I told you I couldn't guarantee the result. That's disingenuous.
Yeah, I agree. As a matter of fact, I remember having a conversation with a colleague many years ago, and like you, I've always been a big fan of alternative dispute resolution. In other words, stay out of court unless you have no choice, right? And this was kind of a, go-getter trial lawyer, no, and I was, arguing with him, or we should say discussing with him a particular case, right? And saying, look, what's the matter with your guy or I don't even remember who he had and who he was representing. Why won't he or she settle, right? This is a reasonable offer. The judges, recommended it. And he's like, yeah, but here's the deal. My client doesn't like that offer. And if I tell him, then he's always going to think I was a bad lawyer and I sold him up the river. But if we go to the court, if we go all the way
Yes.
to trial and the judge makes a decision, I can go, hey, nothing I could do.
Karen, that's exactly right. That's a real thing. I've seen that too. It's easy to hide behind the judge. I've always said it's harder to create. It's easy to try a case. Now, there's going to be a bunch of trial lawyers that have a heart attack if they hear this, but I've tried a lot of cases. I've tried jury trials, bench trials in commercial litigation, juries in personal injury, and divorce cases. And trying a case is easy in that I'm not talking about technically easy. To do it well takes skill and a lot of effort and preparation. What I mean is it's easy because, like you said, you could just fall back on the judge and sort of blame the court for the result. When you're crafting a settlement agreement, there are a million details. And by the way, the judge just writes the judgment. So you don't, or they might ask you to write one version of it. But when you're doing a settlement agreement, it's far more detailed and you have to work out all the bells and whistles and details and a detailed balance sheet and all these things. And go over it with the client many times, make sure they fully understand everything. And when you try the case, it's just like, well, that's the result you get, so that's the roulette wheel you spun. I guess that's it. Like you said, you can just say, oh, that's what the judge says. Well, shrug and that's it. And the lawyer gets their fee and the client's like, well, gee, thanks. And so that's where I get very nervous when a client is in that decision point in settlement. They're contemplating a settlement on the table. They don't love it and they want to go to trial. And I know that it's within the range of that a possible outcome is very close to the settlement. Because I know that's going to be an happy client. If they insist on the trial, it's more than likely to come out the way I think it is, which is closer to the settlement than the fees plus the outcome.
Right.
And I'm worried I'm going to get a very upset client at the end. And it's why did you tell me I should settle? I did tell you. So, you write a long letter explaining everything to make sure that and have a long conversation, walking people through it so they understand. And I think it's, again, a client education is such a important art. And we work with our attorneys in our firm all the time on saying that the most important thing we have is the client relationship. The lawyers in law school are taught to be technicians. There's very little of the human stuff involved. They don't tell you, hey, you're going to have clients. You know, you read all these appellate cases, you memorize statutes, you do trial practice class, but they don't say, oh, you're going to have to find clients and make them happy, and they're going to have to pay you, and they're going to review you on Google and all this stuff. And you realize that it's when you come out of law school, you think it's a law business. And once you practice law for a while, you realize, oh, it's actually a people business.
Yeah.
The service just happens to be law, but it's really a business about communicating with people and conveying what we know to them. Stuff that they want to know, the things that aren't readily available on the internet, the things that are not Googleable, and that important advice and guidance that isn't just something you can get from ChatGPT or a Google search. So
Yeah.
yeah, that's where the value add really is.
100%. I mean, lawyers, they know. I tell my clients, if you could get all the answers you need in your divorce from Google, everybody would be doing it. There would be no divorce lawyers because you
Right.
wouldn't need us. You need divorce lawyers because not only do they know the law, not only do they know the court rules, not only do they know all the details of how do you file this, what do you do, what's next, what's blah blah blah, but they also know the judges.
Right.
Right? And so, like you said, there are patterns that the lawyer will know, and you, as a normal human, is you're going to look and say, "Well, why can't I have that?" And
Yeah.
you can, as the experienced lawyer, can say, "Because I know this judge, and they're never going to give you that. That's not how they think."
It's the difference between reading the rules of baseball and knowing how to play baseball. So you can go online and Google everything about, you can find out all the facts about baseball, strategy, tactics, how to bat, how to pitch, how to catch. And I don't know much about baseball, but this is just a good analogy. And it's like any of these things. You can read up on it, but then when you're in the arena, you have to have that lived experience and have worked in that world to play well,
Yeah.
to navigate it well. And when so much is on the line, the client benefits from that attorney's experience. And you're also buying a certain degree of, insurance, that knowledge and experience and the backing of a team rather than just relying on yourself. And it's so valuable. And the book is an effort to educate um, and give people that perspective.
Yeah, I'm glad you went back to the book because there's an idea that you put forth in there that I'm so intrigued. I gotta hear you explain this. What's the idea, or what's the difference between the washing machine and the swamp in litigation?
Oh, okay. So I talk about the swamp and swamp creatures. Swamp creatures are sort of the, might say the bad lawyers. And I don't want to dump on attorney. I love lawyers. I've been involved in bar association and in the Academy of Matrimonial Lawyers, phenomenal people in the group. There are some bad eggs though. We have to be honest about it. And um, the swamp creature is the person that fights under all circumstances and drags people down into the swamp with them. They are they don't dissuade their clients from aggressive tactics. They file pleadings that aren't necessary. They're Here's the thing. They're ethical and they're legal. So I'm not saying these people are unethical because they if they were, they'd be getting in ethics trouble, but they know the lines.
Yep.
These folks know how to play aggressive tactics without getting in legal or ethical trouble. And they toe the line. So they legally are allowed to do it. They ethically are allowed to do it. But it's a pleading that could have, for example, filing a motion that could have been resolved by a phone call. So call me first, tell me that my client was blocking the driveway with the car and that the wife couldn't get out of the driveway. I'll call my client right away and stop screwing around and don't block your wife in anymore. At least give the other lawyer the courtesy of a call to try to resolve the situation amicably without filing a motion. But instead, you get an emergency motion about how your client's harassing somebody or an attempt to get an order of protection. So it's these hyper aggressive tactics rather than trying to give the other lawyer and other party a chance. And what happens is once somebody starts poking somebody in the proverbial eye, so once that first bullet is fired, so a motion is filed like that, what can happen is the other party says to their lawyer, well, do something. I don't like this. And the lawyer has a hard time telling the client, sometimes the best thing to do is nothing. And that's something I've talked about on my social media and the book too. Sometimes your best action is just sit tight. Well, the client gets mad about that. They think you're weak or you're not fighting. And I want you to fight. They think it's like a movie where if you get punched, you need to punch back. And it's not like that because you just going to get into the cycle of litigation violence with that next motion, and you do what I call feeding the monster. And when you feed the monster, like somebody, that lawyer now, the other lawyer, let's say they're the initial aggressor,
Hmm.
they punch. Now you punch back. Now they say to their client, see, I told you that they were nasty. And now they go, oh, well, let's go around again. And that's the washing machine. We go around again. So we file another motion, and then there's something else that comes up, and now we withhold the kids, and then the next thing happens, and it becomes this tit for tat that gets tremendously expensive, and people just get more and more angry as the washing machine goes around. The fees get higher, people get more mad at each other and their attorneys, and they a tremendous amount of time and money spent on what we call interim litigation, these temporary motions, temporary child support, temporary visitation, temporary spousal support, and then these, order protection or a petition for exclusive possession of a piece of real estate. So to change that to plain English, and you know this, Karen, but for the audience, exclusive possession means you want your soon-to-be ex kicked out of the house. Karen and I know that's hard to do. We know it's very hard from the way the law is in Illinois, but somebody might just insist and say, I want them thrown out of the house. Okay, well, let's file an emergency motion because your spouse did something jerky. I fill in the blank. They did something mean. All right. They file that motion. What are the realistic chances it will be granted? Maybe not so good. The motion gets denied, but the other party gets mad because they tried to get thrown out of the house. So again, we go around and around and around. And what happens is now people are much less likely to settle because they're angry. They've spent a bunch of money on fees and they feel like they make no progress as they're
Yep.
getting no closer to being done. And in Cook County, this is why cases take 2, 3, 4, 5 years rather than 1 year or less, because well, in any county, this kind of thing can just make these cases take on a life of their own because it's no longer about dividing assets and working out the issues with the kids. It becomes personal, and people trying to take out their frustrations on each other through litigation, which, by the way, is the most inefficient method ever devised to take out your frustrations on somebody. You're just making the lawyers wealthy. And I'm not bashing lawyers. It's but people are wasting their money on a lot of this stuff when they could be focusing on getting done. The phrase I use is, are you getting more divorced? Is what you're doing getting you more divorced, or are we just going around the washing machine again? And lawyers are part of the problem and clients are part of the problem because clients are the boss, and lawyers can help and clients can help too. So it's it's definitely a problem, and courts can help too. Courts can nip this thing in the bud by denying some of these motions, by telling parties, clients or parties in court or their lawyers, they're not going to entertain stuff. Sometimes there are motions that we know go in court and we can't believe the court's even entertaining it, but it happens. And I'm not here to say that these are outliers, but it happens more often than it should.
Yeah, absolutely. I remember one time, it just brought to mind a story of one time I was in DuPage County trying a case. We were there. There was nothing to try, like nothing. The people, they had stuff in the house, in an apartment. I don't even know if they owned the house. They
Yeah,
had a child, but thankfully they'd settled the kid issues, right? It was only a trial about money, and there was really not that much that but they were determined to go to trial. And the judge looked down at them, and the judge was like not having this at all, right?
sure.
And so he looked down at them and he said, okay, I understand you want your day in court. I am willing to give that to you. No problem. But just so you know, here's what I'm inclined to do in cases like this. I know you want this stuff and you want the same stuff. So if that's what you come to me with, I can't tell you for sure, but I'm inclined to just say to the sheriff, go in there, sell everything right down to their underwear, and divide the money 50-50. So
Right.
if you want to have all your stuff sold, that's cool. That's fine with me. You got a half an hour, I'll be back.
Right.
So surprising, they settled the case.
Right. That's an excellent example. It's understanding those realities. And I talk about divorce myths in the book. There's a whole section about divorce myths. And one of them is that people don't know what a divorce trial looks like. So they think it's like a movie and they think they're going to get this vindication. And I talk about like the halo and lightning bolt. So they think like, I'm going to get to tell the judge what a bad guy he is or a bad wife she was. And the judge will feel bad for me and I'm going to get more of the money and the kids and whatever it is. And everybody will understand and I'll be vindicated. And the bad person gets hit with a lightning bolt and I get a halo, you know. And we all know that's just not the case. Divorce trials aren't about any of that. By law, they can't talk about any of the stuff that was the whys and wherefores don't matter. It's one, I think once people realize that a divorce trial is a dry recitation of facts and figures, it's a very boring affair, other than maybe drama in a custody case with a maybe serious custody situation. Most divorce trials are very dull because we're going through reams of financial information and to get it to the judge, by the way, in a very inefficient way, because getting a court to, you can't just hand a book to the judge and say, here's everything, read this and make a decision. As you know, we have to go document by document and introduce things into evidence. And it's very slow and methodical. And it's very dull and very time consuming. So there isn't like a sexy moment where the person gets to say, and that's why I'm divorcing them and they're bad and that's it. And then the judge says, ah, well, you're amazing. So I'm just deciding in favor of you and against your spouse. And sorry about your troubles. Here you go. And it never works like that. It's not like the movies at all. It's not like television. It's dreary and pricey. And you're sitting there waiting for the judge to decide, like you said, the fate of your family, your children, and your money. And it's nerve wracking, if anything. And and I'm not here to, sometimes trials are absolutely necessary. I'm not down on the trial business. Sometimes you have no choice. Somebody makes an outrageous demand and they maintain it, or they want sole custody and you were okay with joint custody or sharing decision making. They insisted on sole. Maybe there's made up allegations. You have no choice but to fight. Those are easy cases. I mean, they're easy to decide that you need to try. You have no choice. It's these other ones where some of these are in the middle and they should settle, they could settle, but people for one reason or another get dragged into the swamp and end up in a trial that, unfortunately doesn't give them the bang for the buck that they had hoped.
Yeah. Well, what if I deal with this with clients a lot where they look and they say, well, it's my spouse's lawyer that's dragging us into the swamp. What can you do if you think that it's not your fault, it's the other guy, and maybe legitimately so, I don't know, but like you're being dragged into the swamp and you don't want to go there and you can see yourself going down. What can people do to pull themselves out and end the case?
There are a couple things. One is making that good faith effort to settle. So making a detailed offer. I always like a full marital settlement agreement because you're giving, and that's the document that, I mean, I'm saying this for the audience's benefit. It's the document that resolves all the financial issues and things other than children in the case. Instead of a bullet point offer, which is a summary of main points in a settlement offer, sending a full settlement agreement prevents the other lawyer from saying, well, A, B, and C is fine, but we don't know about all this other stuff. And we can't agree to this because we don't know what the other terms are. So the key is, okay, let me rewind a little bit. First is isolating the problem. So try to figure out, is it the other lawyer? Is it the other party or both? Sometimes it's the other lawyer and the other party's kind of an innocent person in this thing, although I always wonder because they're signing off on all the pleadings. And I think people have sort of a duty to understand what they're doing. But figuring out what is the problem. So in one case, I tell a story where I just thought the other lawyer wasn't educating their client very well. Not that they were evil or had evil intent, but I didn't think they weren't very good at explaining to the client the cost benefit analysis that I've discussed and the reality of the situation as it existed. And it was actually an ongoing trial in Cook County that had taken many months. It was like a day here, a day there. It was a trial with a lot of assets. And the reality was the asset pool was diminishing due to all the legal fees and also temporary support that was being paid. And the case had taken far more time than anybody expected. I took over from a previous attorney. And I wrote a letter that's actually reproduced in the book. The whole exact letter is in there. I just blocked out the names. But I explained what the realistic outcomes were at trial. And I did a full cost benefit analysis in the letter. And I wrote it directed to the other attorney. Now I knew that the client would want to see that letter and say, I want to know what's in that. Because lawyers have a duty to inform their clients about communications, especially settlement offers. So I did the cost benefit. I said, here's what the judge is likely to do. And you've got to be honest about that. Otherwise, the other lawyer says, oh, this is all BS. Don't even pay any attention to this. So you got to be very honest about what the likely outcomes are. And I was probably a little generous on that. Then I said, here's the likely cost. And I was conservative on that, meaning I wanted the client to ask the other party, I wanted the other party to ask their law firm, is this true? Is what Mr. Palmer is saying in this letter accurate? And I wanted them to have to say, well, yeah, it could be. And then the client says, well, is this other stuff true that, we're down to X assets, and if this continues at this rate, we'll have no money left? Well, yeah, that's true too. Well, that stopped the whole thing. We settled the case. And it was just a lack of the other party just either hadn't been informed or wasn't paying attention to the fact that they were fighting over this dwindling pile of money, and that continuing to fight would exhaust all of it. And basically at the end, it would be a complete Pyrrhic victory with just fees owed to the lawyers and then nothing left. And so so that's one effort, is try to reach to the other party, either spouse to spouse. So maybe your client can talk to the spouse directly and say, hey, are you aware this is going on? Have you talked to your lawyer? My lawyer's telling me this. I know you're going to think it's biased or whatever, but this is what my attorney's telling me. He wrote this stuff out. Here's how he sees it. Maybe you should talk to your lawyer about this. Well, that's an angle. Maybe they won't listen, but you can make an effort. One way is the letter I'm describing. Another way is try to get a pretrial conference with the judge, have the judge explain potential outcomes. I find a deposition works wonders to force people to talk. So what happens in this interim litigation machine is we get all focused on these interim issues and the eye poking. And like I said, we're not getting more divorced. Well, at some point in discovery, and I'm telling the audience, a deposition is an oral statement, a sworn statement somebody gives, and the lawyer asks questions. They have to answer the questions under oath. Well, you're allowed to do that. And a lot of divorce lawyers sort of wait until the end to take those depositions. They wait until they're sure there's going to be a trial. And they say, well, I don't want to waste the money and time and all that. Well, sometimes an early deposition is just the thing to get everybody to look at the case objectively. Yep, the lawyer has to prepare, so they have to stop worrying about these interim things and actually look at the potential outcome. They have to prepare their client for the deposition because they're going to have to testify. And then all four of you have to get in the room with a court reporter. Well, what happens is nobody likes depositions. They're a pain in the butt. They can be 3 hours long. It's exhausting. The lawyers don't love them. Clients don't like sitting there being asked questions under that pressure. And so what ends up happening is a lot of times getting all four people in the room after they've had to look at the stuff to prepare for the deposition, they start talking about settlement. And a lot of cases I've seen settle out of depositions where the deposition will turn into a settlement conference. And because sometimes there are lawyers that you just can't get to sit with you in a room. And you'll say, they say time and again, hey, let's sit down and meet, talk about settlement. Oh, no, that's ridiculous. We're filing another motion or whatever. We don't have all the discovery. There's always an excuse for why we can't talk about settlement. When you and I know we could talk about settlement on day one. We might need to get certain information, but there's no reason why we can't start making progress immediately. You do mediations. I know you've done a lot of that, a lot of alternative dispute resolution. In the first collab meeting, in the first mediation, we don't solve the case necessarily, but we make progress. And we don't have to know everything to make some progress. And so I've seen that be a successful tactic, is noticing up that scheduling a deposition and making people pay attention. Um, that's and the thing is, if you know you're in a fight, though, if you know you're dealing with the swamp creature, the person that's going to be fighting, then just go forward and get it done. Then be efficient, get your discovery complete. Don't drag your feet. Make sure you comply with all the court orders. Get the trial scheduled as soon as possible. Then you just need to chug ahead and keep marching. And maybe they'll approach you about a settlement at some point. Maybe they won't. But the worst thing you can do is, once you've got that signal that it isn't happening, to sort of keep trying to make it happen, you know.
100%. And I am the most alternative dispute resolution oriented lawyer when it comes to family law that
Yeah,
you'll ever want to see. And even still, there are some cases, to your point, they just need to be tried, or they're going to be tried because the people are too far apart or the lawyers are too far. But whatever it is, you
right.
just know you can figure out at some point, either maybe not early on, but at least by midway, if not sooner, that this thing is going to have to go to trial, or at least look like it's going to trial. Like, you need that trial date, you need it scheduled.
Yes.
Then, talk to me a little bit, because I've had some people, they kind of they lose hope, they get disheartened because they're like, well, I've got a trial date, I'm going to trial. And how often does that trial really happen?
Only a very small percentage of the time. I think national statistics are about 95% of divorce cases settle before or like at trial. So it's really only a very small percentage of cases. So it's, do a lot of cases settle, on the courthouse steps or the day of trials? Yes, unfortunately they do. Um, why is that? Because unfortunately, people don't sort of focus on getting it done until it's very real. And humans are procrastinators by nature. So the trial date is really important for a flag in the ground, a sense of finality that, if you don't settle, the court's going to decide for you. So a lot of people are in a situation where the one party that keeps avoiding talking about settlement finally gets serious 2 weeks before trial, 3 weeks before trial, a day before trial, because they're going through all the trial prep and they're finally looking at everything. And or the realization really sets in that it is really happening. And if
Yep.
you have a foot dragging spouse, and sometimes people are in just total denial, or, that they don't want the divorce, their mechanism for avoiding divorce is just sitting there and
Right.
doing nothing, and which can be very frustrating on the other side of it. But they'll wait all the way until the bitter end, and then they'll settle like the day before trial, because they realize, oh, it's really going to be done now. I'm really going to be divorced, and it's unfortunate, but that's a fact too.
Yeah, I mean, and there's something about, you make a really good point about the finality of it. Some people, they just don't want to accept that it's happening. And it takes being there on the day of trial. And I've seen, where even with a settlement, you're walking in the door, everything is agreed. It is the day of the final hearing, which in
Yep.
Illinois is called a prove up. And somebody says, wait, I want this one more thing. Wait,
Yep.
and it usually has nothing to do with the one more thing, whatever that was. It was about, I don't want this to really happen.
That's exactly right. And that's where divorce coaches and counselors, and my book is a love letter to collaborative, or to ADR, and also coaches. I would say I have a whole chapter on coaching. I became a believer in coaches when I got into collaborative in 07, 08, and I didn't even know they existed until then. And then they've been huge assets for me, and not only in ADR cases, but in litigated cases. And what I've found in my career is something I tell clients is 90% of what's going to bother you in divorce is the 90% the lawyers can't do anything about. It's, all we can do is, the tool set is very limited. You know, we can call the other lawyer basically or go to court. We can talk, so we can sit down and talk on the phone, on Zoom, in a meeting with the lawyers and the parties. That's one thing. Or we can go to court and do court stuff. Those are the two tricks in the bag. And the only things we're solving ultimately are, and I mean, I know this is complicated, but when we boil it down, we're dividing the property and the debt, we're figuring out support, and we're dealing with visitation and custody. That's it. And all the stuff that drives people crazy about the other spouse and all the emotions wrapped up in and all the other things that make people really upset have nothing to do with those very nuts and bolts things. And so once people realize that, hey, as a lawyer, I can only help you with this subset of the things you're dealing with, that's where the coach is so valuable, so they can address the 90%.
Yep.
And that can make all the difference in these cases, like with the recalcitrant spouse, the person who just can't believe it's happening. Sometimes a coach is critical in helping that person just literally visualize the future, as people will lock down and they say, well, this isn't happening. This isn't happening. And I can't believe I'm going to, all they feel is a tremendous sense of loss, and they lock
Yeah.
down. And that can cause a trial just because they're in denial, and I call them accidental trials. You know, there are these trials that kind of people trip over into them because they just haven't wrapped their head around this thing.
Yep.
Yeah.
Yep. Which is unfortunate, because that's a trial that didn't have to be.
Right, exactly. And it doesn't benefit the parties at all. It's it, and they will verbalize something very different than when they're feeling, like saying this isn't fair. They'll say the settlement isn't fair. What they really mean is the divorce isn't fair,
Right.
that
Right.
life isn't fair, that you know. And I'll tell people, cosmically, you're right. You know, like, you know, emotionally, I understand. Legally, though, it's utterly fair. Like, you know,
Yeah.
pursuant to the law, this is equitable. But you're right. In the grand scheme of things, it isn't fair that you gave 25 years to this person and they've now have a significant other and they cheated on you. That's profoundly unfair. But the court's not going to redress those grievances, you know? So
Yeah. Yeah, I have
it's,
a mentor who used to always say that fair was the four-letter F word of divorce.
I got that from Jim Lenahan, who's a collaborative lawyer. You probably know Jim. He's
Yep. Yeah, I
retired
do.
now. And Jim always said that. And I stole that from him. I love it. It's so true. And you know, your fare is different from the other person's fare. And you know, he would say, is it acceptable to you? Is an acceptable result?
Right.
And also I would point out there's a range of acceptable results. And so that mindset is so important, that it's not fair. And but that's all the court's going to do, is do those few things. And once you understand that, then it helps you see through the clutter and focus on the objective,
Right.
and not get distracted by all this other stuff. Because a lot of the washing machine is, I kind of call, probably maybe too casually, and this is for certain age group because I'm a little older. Three Stooges, like eye poking, you know, poking each other in the eye and not making progress. And a lot of that, I think, is sort of emotionally driven
Mhm.
about how we're angry with each other, rather than, is this materially helping my case? You
Yeah.
know.
100%. You know, Rafe, I could talk to you for hours and hours and hours.
Thank you. You too.
But in the interest of being respectful for your time, I think we're going to call it a wrap right here. But especially for people who might be interested in your services, or in working with a lawyer who does, unbundled services, who will do, different things, just say, hey, I'll just give you advice. I'll do a consultation. I'll do, your documents, whatever. I think that's such a valuable asset for people to know about. Where can people find you? Where's the best place?
So the first place is to come to our website, stglawfirm.com. The firm is STG Divorce Law. So we're very easy to find on the internet. You can also search my name, Raiford Palmer. Just a Google search, you will find me all over the internet and social media. I'm at Raiford Palmer on TikTok, at Raiford Palmer on Instagram, at Raiford Palmer on X, formerly known as Twitter. And so we're very easy to find all over the internet. The book website is ijustwantthisdone.com. And the book is easy to find by searching either my name on Amazon or the book title, and the book will pop right up. So I hope people will check it out. And thank you very much for having me on your show.
You're welcome. Thank you for sharing so much in this episode. I mean, literally, there are so many nuggets of gold here. And for anyone watching or listening, everything, all these things are going to be linked up in the show notes, so you won't have to search for anything. All you have to do is go to the show notes, click on the book, click on his name, click on all the things. And if you enjoyed this episode, if you liked the video, do me a big favor. Give it a thumbs up, like, subscribe everywhere, and I look forward to seeing you again next time.
Thank you.
Thank you.